Also in Georgia this week, the man convicted of killing Georgia nursing student Laken Riley was sentenced to life in prison without the possibility of parole.
In the state of Georgia versus Jose Antonio Ibarra, case SU 24-CR-0323, count 1, malice murder. I find the defendant guilty. Count 1, malice murder. I sentence you to life without the possibility of parole.
Ibarra was found guilty of murder by Athens-Clarke County Judge Patrick Haggart. Ibarra waived his right to a jury trial, instead choosing to allow a judge to decide his fate. Federal authorities say Ibarra entered the country illegally back in 2022, but was allowed to remain to pursue his immigration case. Prosecutors say Ibarra attacked Riley as she was running on the University of Georgia campus last February. She was a student at the Augusta University College of Nursing, and she was just 22 years old. Meantime, so-called judge shopping continues to be a controversial topic as we saw a federal judge sharply criticize Georgetown law professor Steve Vladic over even suggesting that judge shopping happens, something even conservatives said was out of line. But first, what is judge shopping? Judge shopping is kind of like what it sounds. It's when you strategically file a lawsuit in a particular court, in a particular geographic region, even if the connection to the case is tenuous at best, all because you're trying to get a particular judge who you think will be favorable to your case. For example, there is exactly one federal judge in Amarillo, Texas, Judge Matthew Kaczmarek. He's a conservative judge appointed by Donald Trump, and he has a demonstrated anti-abortion view. Now, the Alliance for Hippocratic Medicine filed their challenge to the abortion drug mifepristone in his district, and then they got a nationwide injunction effectively canceling the federal government's approval of the drug, at least temporarily. Now, the Supreme Court ultimately reversed the decision, but it's an example of judge shopping. Now, the counter-argument is this isn't a bad thing. This is what plaintiffs do. They choose their venues strategically to get the best chance at a win. Now, last week at the Federalist Society's annual gathering, Fifth Circuit Judge Edith Jones went after Vladic for his criticism of the practice, a move she took heat for even from her fellow conservatives.
And then he says, the then EIC who allowed Kaczmarek to pull this nonsense is one of the lead lawyers steering Texas challenges. On another one, he says...
You might note the context in which I said that, which was about something that happened before he was a judge.
I don't think that's the case.
Yes, it was about a dispute over a law review article that was changed.
You're still saying, you're referring to the judges pulling nonsense. It's part of a pattern. I've just got 3 more.
I do appreciate Judge Jones making my point about how we're shouting past each other and not engaging on substance.
I'll just say you don't see typically that kind of interaction with a federal judge in public like that. Now, Jones says it was not meant as a personal attack, but what you can't see there is the folder of past comments from Vladic that she had printed out and was reading aloud to the audience. Now, putting aside the issue of how to disagree on the law in a forum like that, or in any forum for that matter, this is clearly a hotly debated topic, and it's one that's going to continue into the next administration, as Trump is going to have a chance to remake the federal judiciary all over again with his appointees after he successfully appointed 231 judges to the federal bench, including 3 Supreme Court justices, all during his first term. Meantime, in our region, the head of the National Child Research Center preschool in Northwest D.C. is in jail. The FBI arrested James Carroll, accusing him of trying to get abusive videos of a minor. Carroll used the messaging app Discord to communicate with an undercover agent who posed as the father of a young child from November 5th to November 14th. The U.S. Department of Justice says Carroll directed the undercover officer to abuse his child over the period of approximately 2 weeks. And then Carroll allegedly tried to solicit sex abuse videos from the undercover agent. The affidavit also states Carroll said he had an interest in boy pics and that his age preference was 8 to 12 years old. There are more details in that affidavit that are too disturbing and graphic to share. But FBI agents say they were able to identify and track Carroll down based on his IP address, and a federal judge in D.C. has ordered him held without bond. Also in D.C., 2 of the 5 teenage girls who fatally beat Reggie Brown in an alleyway off Georgia Avenue in October of last year were found guilty of second-degree murder and assault this week. If they were adults, they would be facing life in prison, but D.C. law requires that they be released by the time they turn 21 at the latest, something Brown's family wants to change.
As you all know, there's some other 14-year-old kids who had done this to a DJ over the weekend last week. So our fight is going to be to try to change the laws from 21 years old for juveniles that they can stay in and possibly stay in jail for life when they brutally kill someone like they did my brother.
All 5 girls were between 12 and 15 years old. The other 3 involved have pleaded to related charges. 2 of Brown's sisters blame the city's Department of Youth and Rehabilitation Services for contributing to juveniles, including in this case, reoffending. The embattled agency has actually been criticized by D.C. leaders for a while now, including the Attorney General. They're facing a separate lawsuit filed by the ACLU and D.C.'s public defenders for mismanagement and internal failures.